Thank you, Mr Speaker.
Cool. Dr Cam Calder.
Mr Speaker, it's a pleasure to rise and make a brief contribution to the third reading of the Search and Surveillance Bill. Mr Speaker, the first responsibility of the state is to protect its citizens. And this bill is our attempt and the work of a number of years and the contribution from all sides of the House to do this. And I want to acknowledge the work done by the Honourable Chester Burrows as the Chairman of the Select Committee when this bill was considered in its first stages. I would like to pay credit to the contribution from the other side of the House, Honourable David Parker and Charles Chevelle, who have contributed to this, and of course the work done by the Honourable Judith Collins in being open-minded to the concerns that have been brought to her attention from various quarters. And the size of the SOP that we had at the Committee of the Whole House attests to her flexibility in being responsive to these concerns. Now, the bill is designed to bring consistency and clarity and certainty to an area which we have heard from numerous contributions has been somewhat turbid and difficult to ascertain a way through because of the plethora of statutes that are concerned with search and surveillance across all levels of society. The bill seeks to strike a level between effective law enforcement and the protection of rights of citizens as set out in the Bill of Rights. And I'd like to make this point that in fact we believe that we have been successful in doing it. The bill explicitly states that its purpose is to balance law enforcement and investigation powers with human rights values. And there are a number of safeguards in the bill to achieve this. First of all, there has to be independent authorisation. The bill adheres to the basic concept that independent authorisation is needed before exercising search powers. Enforcement officers must justify the exercise of search powers to neutral issuing officers. There are detailed reporting requirements to the issuing officer, the chief executive of the relevant agency, and to Parliament on the exercise of search and surveillance powers. So we believe that the human rights concerns are being met. Thirdly, and also extremely importantly, the bill doesn't affect New Zealanders' rights under the New Zealand Bill of Rights to be free from unreasonable search and seizure. One of the key changes, and Mr Clinton has alluded to that, one of the key changes to the bill is to commence before the 18th of April. And the reason why this is necessary is because the Video Camera Surveillance Temporary Measures Act 2011 expires, and there would be a gap in significant and serious criminal investigations if this bill did not come into play before then. Another concern that has been raised is media freedom. A key change in the bill, and this is a response to concerns raised and was addressed in the SOP, a key change to the bill enhances media freedom. It's been made in recognition of the crucial role of the media in a free and democratic society and to preserve the important principles of media freedom. At the moment, the media can't prevent material being seized from a search, but as Mr Chevelle observed, the custody of documents has been titled up under this bill until a claim of privilege has been determined. So any documents that are seized are held by the High Court until the claim of privilege has been determined. So this is extremely important. I'll just finish with a comment about political activism, because on all sides of the House we believe in the New Zealanders' right to make their points without fear or prejudice, and the 7-year threshold in the bill means that examination orders are not available to investigate such crimes as protesting, trespass, disorderly behaviour or unlawful assembly, the sort of crimes that you'd expect to, at the lower end of the scale, that a normal political activist may get involved in at some time or another. Mr Speaker, I commend this bill to the House.
I call Dennis O'Rourke.